right, welcome to the video lecture for Social Psych and the Law. Glad you found everything okay. So this is our last topic of the term, right? We had to switch it to a video lecture because of the snow days, but it's really interesting and important information, so I didn't want to cut it entirely. So let's go ahead and dive right in. So the responses for this you will find clearly marked throughout the slides here. I recommend you treat this the same way that you did the other video lecture on attitudes and persuasion, right? Take notes, learn the stuff. It'll be on the exam, the final exam as well. Let me know if you have any questions about that. But in the meantime, let's go ahead and get going. All right, so within this topic, we're going to talk about three main ideas. We're going to start out by talking about whether eyewitness testimony is reliable. Then we're going to talk about whether jurors can ignore inadmissible evidence, and then we'll talk a little bit about whether how well lie detectors really work. And I want you guys to know this is only a very tiny introduction to actually a large subfield of social psych and the law. So if you're interested in these topics, there's a lot more that you could potentially learn about these, but consider this kind of a smattering of information that displays how social psych can be applied to a legal context. All right, let's go ahead and start off by talking about just how reliable eyewitness testimony is. Okay, now to get us started on this, I actually want you guys to pause the video lecture and go watch this video. So this is a 15-minute video. It's an old 60-minute special about the case of Ronald Cotton. I have the link here, but I also linked the video in the folder. So if you go back to the folder where you found the video lecture, you can find the link to the YouTube video here. I recommend go ahead and watch that video first and then come back and continue, because we're going to use this case to frame some of the ideas we're talking about today. Now, I do want to give you a content warning that this is a video about crime, right? And the particular crime in this video is a rape. So you're going to hear Jennifer Thompson discuss what happened to her some years ago, and then we will talk about how, or she will talk in the video about how it happened, about how it led to what happened with Ronald Cotton. So go ahead and watch that, and then come back when you are done with it, and we'll keep going. All right, so I'm going to assume that you've gone ahead and watched that video and you're ready to keep going, so let's go on. All right, now the video that you just watched is about a false conviction, right? What happened to Ronald Cotton. We're going to talk today about some ideas about that. So here you can see two images here. Bobby Poole is on the left and Ronald Cotton is on the right. And you can see that they sort of a little bit look similar, but we're going to talk about a lot of things that contributed to what happened in this case beyond just the similarity in their physical appearance. So we're going to talk about what factors led to Ronald Cotton's false conviction and his 11-year imprisonment. And we're going to talk about what we can learn from this story to prevent this from happening in the future, because social psychology has a lot of good insights about why something like this happened, and similarly how we can prevent this from happening again in the future. All right, we're going to start out by talking about eyewitness testimony. Now, I want you to remember that in that video that you just watched, the 60 Minutes video, Jennifer Thompson was sure that Ronald Cotton was the rapist, 100% sure, completely convinced. But eyewitnesses, right, this is the key, that eyewitnesses are imperfect. She was an eyewitness in this case, and her testimony ended up being wrong. 75,000 eyewitnesses testify in cases every single year. And of course, what's more convincing than an eyewitness pointing a finger, right? People tend to think this is the most damning piece of evidence you could possibly have. However, eyewitness testimony is subject to a lot of issues, and a lot of it actually has to do with something we were just talking about in stereotyping and prejudice, and that's memory processes. So memory we talked about before a couple times. Memory processes, this is not a camcorder, right, where you're perfectly recording what you see and replaying it later. Memory can be extremely biased in a lot of different ways. And we talked a little bit before about how there are several stages in memory. So there is encoding, the encoding stage, where you're taking information into your memory, right? You're seeing things as they happen, you're putting it into your memory. There's also the storage stage. This is where you're retaining encoded information, so you're storing it in your memory over time. And then there's the retrieval stage, which is where you're recalling stored information and bringing it back to the front of your mind. Now, memory processes can be affected at any stage, and we talked about this before in stereotyping and prejudice, right? as well as in social cognition, a few other places. Memory is not really a recorder. We don't play back memories exactly as they occurred. Instead, it's very subject to biases. And this kind of bias can be a lot of the problem with eyewitness testimony, because eyewitnesses are relying on their memories, but of course their memories can be interfered with at any stage, even without malicious intent. All right, now we're going to start off by talking about some encoding problems. So this is where you are putting information into your memory as you see it happening. It turns out that a lot of research supports the idea that your emotional state influences how you encode information into memory. So specifically, research shows that arousal, physiological arousal, tends to really focus our attention on central features of what's going on in front of us. So feeling physiologically aroused, which, as you can imagine, is the kind of emotion that you're experiencing if you're the victim of a crime or if you're watching a crime happen. You're probably feeling angry, or maybe you're feeling scared, right? This is arousal, right? And this can lead you to really focus only on central features and can lead you to overlook other features. So it has this huge effect on encoding ongoing events into memory. The fact that you're experiencing a strong emotion in the moment means that you are not necessarily taking everything in that you see in front of you. Instead, your attention is really being focused on central aspects of what's happening. So one specific problem with this is something that we call the weapon focus. So weapon focus, this is the idea that the presence of a weapon at a crime or anywhere else draws our attention. You can think about how this evolutionarily makes sense, right? We know that guns are very dangerous items, or even not even guns necessarily. If somebody's holding a baseball bat and they're walking around with it outside of a baseball field, that can be very threatening, right? If somebody has some kind of a weapon, that tends to draw our eyes, because we need to be aware of that, right? We need to be aware of the fact that somebody has a weapon. We need to keep our eyes on it and know where it is, what's happening, what they're doing with it at all times. But that then has this secondary effect when you're an eyewitness to a crime, that your eyes are looking at the weapon and not necessarily the face of the person holding it. So your eyes are focusing in on that most salient aspect of the situation, which is the weapon, which means that you're not necessarily looking at the person holding it, which makes it more difficult to identify the culprit. So if you're not really paying attention to their face or what they're wearing because you're so focused on the weapon that they're holding, then of course you're going to have problems putting that information of what they look like into your memory because you're not even looking at it. And this can be a huge problem. Now, encoding is not the only place where memory processes can go awry when it comes to eyewitness testimony. We can also talk about storage problems. So remember, storage is where you are storing information in your memory over time after it's been encoded. And research suggests that our memory for faces and events fades over time. So over time, as memories stay in our storage, we remember them less clearly, less sharply. So you think about, try to remember something that happened to you 10 years ago. It's very hard to remember details, right? That's because of this kind of degradation while in storage. So memory for faces and events fades over time. This can be compounded as a problem in eyewitness testimony when you consider the fact that if you're being asked leading or repeated questions, it can then bias your memory. So post-event information can also affect memory storage. Leading questions, so for example, if somebody asks you, were you at the bar on the night of November 20th, versus where were you on the night of November 20th, right? That's a leading question. If they're asking you something with a specific tilt, just the fact that you've been asked something with a specific angle can actually impact your storage of that memory. So research shows that kids, in fact, are especially susceptible to leading questions. They're the most likely to have problems with maintenance of memory over time when asked leading questions, but adults can be impacted too. Now remember, before I give you a specific example of how leading questions can bias memory, remember from that video that Jennifer Thompson could only remember Ronald Cotton's face as her rapist, even though he wasn't, right? She practiced that memory until it was real. So the memory for the actual face of the person who committed the crime faded over time and was replaced with the face of Ronald Cotton. This is, as you might consider it, a storage problem at heart. All right, and I'm going to give you an example of a study that demonstrates how leading questions can bias our memory. This study was done by Elizabeth Loftus, who has done a ton of research in this area and written several books on her findings. She's actually a cognitive psychologist, very famous in the area of memory research. She's done a ton of really interesting research on this topic, and I'm going to tell you about one of her studies now. All right, so here is our example of leading questions impacting storage of memory. So this is a car accident study, one of the early studies that Elizabeth Loftus did demonstrating this kind of effect. What happened in this study is that participants come into the lab and they watch a film of a car accident. So it's just a film of two cars hitting each other, right? It's a pretty short clip. It's the same clip. Everybody watches the same thing. But the independent variable is that after everybody watches the film of the car accident, they're asked to remember something about the video, but they're actually asked it differently. So they're asked, how fast were the cars going? Everybody's asked that basic question. How fast were they going? So they're supposed to give an estimate of miles per hour of how fast the cars were going. But the researcher finishes this question differently depending on the different conditions. So in one condition, they're asked, how fast were the cars going when they contacted? In a second condition, they're asked, how fast were the cars going when they hit? And in the third condition, they're asked, how fast were the cars going when they smashed? So you can see, same question, how fast were they going? But in these three different conditions, different groups of participants heard a different kind of action word at the end of that sentence. You can think about how the way they're ordered on the slide here, they're kind of in increasing intensity. Contacted sounds kind of minor. Hit maybe a little worse. Smashed sounds pretty intense and vivid. Loftus and her colleagues in the study were looking to see, does getting asked the question differently in this kind of leading or non-leading way, does that impact how people remember what they saw in the video? So this graphic here, you can see this is depicting the results of the study. So you can see the question there about how fast were the cars going when they smashed, hit, or contacted each other. You can see the verb in the middle there, and then on the right side, estimated miles per hour. This is the average estimated miles per hour that participants gave in each of these conditions. So in the condition where they were asked about, when they were asked the question with the smashed word, wording in the question there, their estimated miles per hour was about 40.8. For the participants who got the word hit in that question, it was 34. And then the ones who had the word contacted in that explanation, or in that question, is about 30.8. So look at smashed versus contacted, 40.8 versus 30.8. That's a difference in 10 miles per hour. That's actually quite a large difference in their estimations of how fast the cars were going. Remember, they all saw the exact same video clip. Nothing different about the video clip, nothing different about the experiment, except for this different wording in the question. So you can take this as evidence that when you're asked a question with a leading tilt to it, like the person being asked, hey, how fast were the cars going when they smashed into each other, that can impact your memory of that event. That same exact event, you recall it differently just because somebody asked you the question with a different angle. Now, something else interesting about this study is that they also asked participants whether there was broken glass at the scene. Now, in reality, in the video, there was no broken glass. But, you know, it's been a little bit of time since they watched the video. They're asked how fast the cars were going. Then they're asked, hey, was there broken glass in the video? Do you remember seeing that? For the participants who had the verb smashed in their question in that condition, they were more likely to say, yes, there was broken glass in that smashed condition than in the hit or the contacted condition. So it also impacts memory of additional information beyond just the question itself of how fast they were going. So the way questions are worded can actually very seriously bias our memory. You can think about how this probably impacts a lot of legal situations where people in trials are trying to get people to answer certain ways. They might ask leading questions on purpose and thus influence their witnesses. Now, one other interesting thing about memory storage is that it's so malleable that you can even implant false memories. So you can make people believe that they had an experience that they never actually had. So for this, I want you guys to go back to the folder on Blackboard where the video lecture files are. I also linked to the second video here, which has Elizabeth Loftus talking about some of her research on planting false memories. It's about 1 minute and 45 seconds long. Go ahead and jump on over there, watch that video, and then come back. All right, so I'm going to assume that you have watched that video and come back here. So does that make you nervous that maybe some of your memories aren't real? It's a possibility. So I do want you guys to know that in Loftus's research and other people's research on this topic, not everybody believes these false memories they're trying to plant. So some studies show that it's actually a small minority, not tiny, but it's a minority of people, like maybe 25% of people who are likely to believe when they've been implanted with false memories. But that's like a quarter of people, right? If you and four other people you know, or you and three other people you know, one of you would probably believe this false memory. So keep this in mind as something that happens. There's a lot of other research and a lot of other discussion on implications that this has in different aspects as well. So if you're interested in that, you should feel free to Google this and read up on it. It's interesting stuff. All right. Okay, now the last stage of memory then is about retrieval, and there can be some problems introduced at the retrieval stage of memory as well with eyewitness testimony. Now remember, retrieval is about pulling the information out of memory. And research shows that every time you retrieve a memory, you bring it back to the forefront of your mind, you think about it, you replay it in your mind. Every single time you do that, it increases the risk of distortion. So if you think about being an eyewitness, eyewitnesses engage in retrieval multiple times, right? Every single time they have to recount what happened to a police officer or to a lawyer or in front of a jury or even just to friends and family. Every time they have to restate what happened to them, each retrieval is going to increase the risk of distortion. So every time they think of it, there's more and more likelihood that what they originally put into their mind is going to become distorted over time. Now, related to this, research has shown that the lineup procedure in identifying a suspect in a crime can actually pretty strongly interfere with retrieval. So the way the lineup is constructed can actually hurt eyewitness accuracy. So lineup construction, right? Research shows that sequential lineups are actually much better than simultaneous lineups. So sequential, this means one after the other. So you see the first person, they come into the room, you say, yes, that's them, or no, that's not them. They leave the room, the second person comes in, you say yes or no. They leave, the third person comes in, you say yes or no, etc., etc. So sequential, you're seeing people one at a time. In simultaneous presentation, you're seeing everybody at once. So simultaneous presentation, this is like that standard lineups that you'll see in movies and TV shows, right? Everybody is standing there holding a number, and then you're looking at all of them and deciding which one is the one that you saw. So it's actually much better to do a sequential than a simultaneous presentation, to see them one at a time instead of all at once. The reason behind that is that if you're doing a sequential lineup construction, people have to make absolute judgments and not relative judgments. So absolute judgments meaning yes or no. So that's them or that's not them. Whereas in a simultaneous presentation, you can compare each of them to each other, make a relative judgment and say, well, of these 5 people, number 1 looks the most like the person who I saw commit this crime. So this idea of making relative judgments is actually quite problematic. You can probably think about how this played out in the 60-minute special that you guys watched a little bit ago. So better meaning that in a sequential lineup, people are less likely to choose the wrong person, so they're less likely to misidentify the suspect. As it turns out, a little tidbit here, the best lineup is actually a double-blind sequential presentation, which is where no one knows who the suspect is or whether an actual suspect is even in the lineup. So that means that the police officer, whoever who is facilitating this lineup, they don't know who the suspect for the case is, which of the people it is, and they don't know whether the suspect is even in the lineup, and neither does the eyewitness. So the idea is that nobody has any idea whether that person's actually there or not. Therefore, you can't have these pieces of implicit bias that get in where people are thinking, you know, oh, I hope they pick that person, that's our suspect, and then might very subtly behave in such a way to make that happen. So the eyewitness doesn't fall prey to relative judgments in that kind of situation, and the police officer facilitating it also doesn't let their own biases interplay as well. Okay, last video for this video lecture then. One more video for you guys. This is on lineups. So this is less than 3 minutes long. Once again, I have the YouTube link here, but you can also hop back over to the folder on Blackboard where I've linked this as well. So go ahead and watch it and then come back when you're ready to keep going. All right, so I'm assuming that you guys have watched that video. So you saw in that video, right, that innocent people are still being selected. So doing a sequential lineup instead of a simultaneous one is not perfect. It doesn't mean that you 100% always pick the right person and never pick the wrong person. It's not perfect, but it's definitely better. And when we're thinking about something as delicate as the law or legal context, legal proceedings, why not just try to be as good as possible? Do everything you can to make sure your process is better. Okay, now one more really important factor that affects retrieval is something that we call the cross-race effect, or you might have seen it called the race identification bias. This is the effect where it is actually easier to recognize and differentiate faces of people who belong to your race. So it's pretty well established phenomenon that people have trouble identifying members of other races. So if I'm white, right, and I'm seeing lots and lots of Native American people, it might be harder for me to identify people as different from each other. Or if I'm Native American, I'm seeing a lot of white people, vice versa, right? It's hard for me to identify them from each other. So cross-race effect, it's easier to recognize and differentiate faces of your own race. So the reason why this happens is that it's actually related to things we talked about before with this idea of in-group, out-group. So specifically in this case, groups according to race. The less contact that you have with people of other races, the more this affects you because they're not part of your in-group. So because you're not seeing people who belong to that race very often, you're not as skilled at picking out different features of people who belong to that race. So the less contact you have with people of other races, the more this affects you. So research shows that the more contact you have with members of groups other than your own, the less of a problem you have with this. Now this is also known to impact age. So with cross-race effect, you could also consider the cross-age effect. So if I'm a teenager, I would probably have a lot of trouble recognizing and differentiating faces of senior citizens, of elderly people from each other, and vice versa. If I'm a senior citizen, I might have some trouble recognizing, differentiating teenagers from each other. So this applies across age divides as well. But interestingly, it does not apply across gender divides. So if I'm a female, I don't necessarily have problems identifying male faces from each other or vice versa. And you can think about that as being because gender contact is pretty unavoidable, right? We talked about that in Stereotyping and Prejudice too, where our population's about 50-50 right now, so you typically have a lot of experience dealing with or seeing and interacting with members of a gender other than your own. Okay, now one more little piece of information. Regardless of whether their memories might be distorted, there's one more important thing to keep in mind about eyewitness testimony, and that's eyewitness confidence. So eyewitnesses tend to be very confident when they're giving their testimonies to police officers in front of juries, etc. And why shouldn't they feel confident, right? They know what they saw. However, research shows that eyewitness confidence does not actually signal accuracy. So it's not actually the case that the more confident an eyewitness is, the more accurate they are, that they're recalling it correctly. If I remember right, there's no correlation between those two, which means that confidence has nothing to do with accuracy. And you can think about how that could arise from all of the things that we've just been talking about with memory, right? People often don't realize that their memories are so malleable, that they're so subject to bias. People don't even realize that. So when they're up there recounting what they've seen, they don't understand, they don't recognize that they've had some issues, they've had some biases introduced to their memories. They have no idea. They just think, yes, this is exactly what I saw, even though it's actually not. So even though eyewitness confidence does not actually signal accuracy, people tend to think that it does. And you can see why this makes sense too, right? If someone is very confidently saying, yes, I definitely saw that person, that's very persuasive. If I'm a judge or I'm a jury member and I'm seeing this eyewitness point the finger and say, yes, that's the person who committed this crime, I saw it with my own eyes, I'm going to find that very convincing. So accuracy never really matches the level of confidence, and yet confidence appears very persuasive in the courtroom. Now, one thing I want you guys to keep in mind about this stuff and everything we're about to talk about too is that we know this in social psychology, and now you know it too, but judges and juries don't know this stuff. They typically don't understand how this stuff works. If you go ask the everyday person about how memory works, they're probably not going to be able to give you the same answer that we've been talking about in this class, the correct answer about how it's so malleable, it's so changeable, so subject to bias. People just don't know this stuff. And this is part of what contributes to the problems with eyewitness testimony. All right, that brings us to our first video lecture response. So video lecture response number 1 is to think about how the concepts we've talked about so far might have affected the case of Ronald Cotton. So I want you guys to think back on what we talked about already and about the video you watched earlier, and choose at least 2 concepts that you've seen so far and write a paragraph or 2 explaining how these concepts played out in this case. So you can just name this document whatever you wanted to, save the same document, and you can add on to it with a second video lecture response toward the end of the slides here. So go ahead and take a minute and do that. All right, once you're done, let's go ahead and forge onward with our video lecture. All right, so now that we've talked a little bit about just how reliable or unreliable eyewitness testimony is, now let's talk about a different aspect of the law, which social psychology also has insights into. So we'll talk a little bit about what happens when evidence gets ruled as inadmissible in a court setting. All right, so another little tidbit here about how social psych can inform the law. When evidence gets ruled as inadmissible, so that means if it's ruled that it can't be factored into the jury's decision, or for example, because it was improperly obtained, or it's prejudicial, or it's hearsay, or it's irrelevant. In that case, if evidence should not be considered in the jury's decision, the judge can instruct the jury to disregard the evidence that's been presented. So if you have watched, Law and Order, CSI, other like courtroom dramas on TV, for example, you've probably seen examples of this all the time. The prosecutor says, "Oh, what about this?" And then, somebody else says, "Oh, the objection, strike that from the record," all that kind of stuff. That's inadmissible evidence. So the question is, when that happens in real life, not just in courtroom dramas, can you really get people to completely ignore evidence? So this is specifically looking at members of the jury who hear this kind of information. Then the judge says, "Oh, don't consider that. Can you really strike something from people's minds? Can people really ignore that kind of information if they're given it and then told not to consider it?" So I'm going to tell you about one study here that demonstrates whether this happens. So this inadmissible evidence study. The idea here is that participants are instructed to act like jury members. So they come into the lab and they're told, "Hey, this is about, legal settings, jury processes." So what they do is they give their participants a murder case with just some details about some murder case that has very weak evidence. So the idea is the evidence that the suspect in this crime, the evidence that they actually committed the crime is very, very weak. It's very tenuous. Now remember, in a jury's job is to decide, is it beyond a reasonable doubt that this person is guilty of the crime that they're on trial for, that they're being accused of? Is it beyond a reasonable doubt? So there's very weak evidence, not very strong at all. In the control condition in this study, where they just do what's listed here, they read the murder case with weak evidence, literally nobody, so 0% of the participants vote the defendant guilty. So that's how weak the evidence is. Very, very weak, not strong at all. So in this case, nobody says they're guilty. This is our control condition, right? So this murder case information is not strong at all. Now, the key here is that there are 2 other conditions in this study where participants read that same murder case with weak evidence, but they hear an additional piece of evidence. So they hear a phone conversation that implies the guilt of the person who is the suspect or the defendant in this trial. So they hear a recording of a phone conversation between the defendant and somebody else. The defendant tells this other person, "Oh, I finally got the money to pay you off." So that sounds a little guilty, right? You could think that, whatever the crime in this case, that maybe that's what's leading them to have the money to pay this person off. Sounds like they're guilty, more so than just the murder case with weak evidence alone. But the key here is that in these 2 other conditions where participants hear this phone conversation, in one of the 2, the evidence is ruled admissible. So the judge in this case says, "Yes, this is properly obtained. You can consider this in your decision along with the other evidence in this, just written description of the case." And in the other condition, that's our key condition here, this evidence is ruled not admissible. So the idea is that they hear the phone conversation and then they're told, this is improperly obtained evidence. You cannot consider this in your decision making. So you should strike this from your mind. This is inadmissible evidence. All right, so this is going to be the results from this study. So on the y-axis, you can see the title of the graph here. This is percent ruling guilty. So this is percent of the participants in each condition who think that the person who is on trial for this murder case that they've read about, this percent of people who think that they're guilty. And you can see the 3 different conditions here. So the green bar is going to be the no tape. It's their very first condition where they just read the very weak evidence. The pink condition, the pink bar is representing the condition where they hear the tape that sounds kind of guilty, and the judge says, yes, you can consider this in your decision. Whereas the yellow bar is where the tape is disallowed, so they hear the tape that sounds a little bit guilty, and then it's ruled as inadmissible. So that's going to be our key condition here. All right, so first if we look at the green bar here, you'll see that there is no green bar. That's because this is the thing we already talked about, this very first condition or control condition where they're just reading this incredibly weak evidence and nobody rules them guilty. So 0% of participants think they're guilty. It's our baseline condition. We can compare that against our condition where they hear the tape implying guilt and it's ruled admissible. So this pink bar here, this is indicating that 26% of participants in this condition think that the defendant is guilty if they hear that tape where they say, I finally got the money to pay you off. Now notice this is not everybody, right? So about 75%, about 3/4 of participants think that that's not strong enough. You know, maybe it's not strongly linked enough. They could be talking about something else. Because remember, right, you're supposed to be beyond reasonable doubt when you convict somebody of a crime like this. So about 26% of people rule guilty, but that's a significant difference from when the tape is not, from when there's no tape at all, right? So it indicates that that tape is being used in their decision making as it's ruled admissible, as they should be using it in their decision making. But of course, the most interesting condition we have here to answer our question for this part of the lecture here is whether you can really strike something from your mind if it's ruled admissible. If they can do that, if they're told something, they're told this evidence, and then they're told, oh, this is improperly obtained, you can't consider this in your decision making, or this is hearsay, it's irrelevant, right? Don't factor this into your decision. If people really can ignore that information, then the percent of people ruling guilty in the tape disallowed condition should be 0. We should be matching our lack of a green bar here, because in that case, they should only be considering the written information about the case with the very weak evidence, which our control condition, we had 0 people ruling guilty. The question is, does that happen? The answer is a resounding no. So look at our yellow bar here. This is 35% of people in this condition rule that defendant guilty when the tape is disallowed. Now this is flying in the face of the idea here, right? And this is actually even significantly different from our pink bar condition here where the tape is allowed. Indicates that when that evidence is ruled inadmissible, people are actually using it more in their decision making. They're told not to use it at all, and they're actually using it even more than when that tape is allowed. So you can see this difference here between the yellow and our pink bars, and of course a big difference between our yellow and our green bars, indicating that if evidence is ruled inadmissible, not only can you not strike it from your mind, you actually are likely to use it even more in your decision making, even if you're told not to. Now in this study, they do some debriefing and they asked participants later at the end of the study about their processes, their decision making. And in this case, the condition, this yellow bar condition where the tape is disallowed, people said that the tape didn't affect them. They said, oh yeah, I followed the instructions. I didn't consider that in my decision making. I ruled them guilty or not, just depending on that, the evidence that I read about in that description. But of course, that's not true, right? If you look at, they should have had the same as the green bar condition, but they did not. So people don't even realize that they're using that information when they shouldn't be, and yet they are. So this idea of, can you strike something from your mind if something's ruled inadmissible? The answer, as indicated by this study, is pretty clearly no, you cannot. Now you might be wondering why this happens, and there's actually several reasons that we can talk about for why this kind of thing might happen. One is simply about where your attention is drawn. So the instruction to disregard a piece of information, that instruction by itself draws your attention to it, perhaps even more so than if the evidence is just presented, with no additional discussion of it. So hearing the evidence and then hearing the judge say, oh, you can't consider it, to disregard that testimony, for example, that makes it even more salient. You're paying attention even more to it than if you were just hearing the evidence as is. The fact that you're paying more attention to it means that even if you don't want it to, it can then be used in your decision making more than if it hadn't been as salient. So that's one explanation for why this happens. Another is simply that it's actually pretty hard for us to ignore relevant information. So people are typically pretty motivated to be accurate jury members to make the right decision. And to do that, of course, we have to use all the information we can to make that decision. So ignoring a piece of information that sounds relevant, it can be really hard to do, right? If something like, oh, it's improperly obtained, that often makes us think, yeah, but if it was properly obtained, this would be pretty damning evidence, right? So it's hard for us to ignore something that might be relevant like that. even if we are trying to ignore it, that can backfire too. So something like thought suppression can happen. If you think back to social cognition, and more recently in stereotyping and prejudice, we talked about the effects of thought suppression. When you're trying hard not to think about something, like our white bears demo, right? Trying hard not to think about it, you end up having this ironic thought suppression effect where you think about it even more, right? So you're trying to distract yourself. You've got that automatic process that's searching for the thought. These processes both actually make it more accessible, make it more salient, and make us think of it even more. So even for people who are trying hard to obey that instruction to not pay attention to it, they might experience thought suppression effects where it backfires and they think of it even more. One other explanation that some psychologists have put forth as another reason why sometimes this kind of effect can happen is that this instruction to not pay attention to evidence can actually induce reactance. So reactance, right? Remember back when we talked in social influence about why people might disobey authority figures? We talked about one reason being reactance. We talked about how this is the kind of thing that happens in reverse psychology, right? If I tell, my nephew, oh, don't eat the candy, that's not for you, he's gonna be like, oh, I'm gonna eat the candy. Or somebody tells me, oh, you can't do that, I'm like, oh, I'm gonna do it, watch me, right? That's this kind of a reactance thing because we don't like feeling like our freedom is being threatened. So sometimes that can lead us to disobey. That same thing could potentially happen in this kind of situation where the judge says, don't pay attention to this information, strike it from your mind. It can end up inducing some of that reactance in us and make us then more likely to go against that instruction and go ahead and use it in our decision making. So you can see some of these explanations are a little more conscious and thoughtful, like perhaps what's happening with reactance, but some of them are so subtle that you might not even realize that you're being affected by them, like the fact that it's drawing your attention or that thought suppression might be going on here. All of these things can combine to make inadmissible evidence very hard to actually ignore. So whenever you're watching courtroom dramas, right, and you see people do this where they make some side comment or they conjecture about somebody's motivations, and then somebody else steps in and says, oh, objection, you can't say that, and say, yeah, strike that from the record. They're doing it for a reason, right? Because even though it might be omitted from the official record, the jury has still heard them say that. And even though they're told not to use that in their information or in their decision making, they still typically are using it. So that happens for a very clever reason, actually, for why people do that kind of thing. So keep that in mind the next time you watch Law and Order. All right, and the last thing we're going to talk about just a little bit here is about lie detector tests. So this is actually a pretty hotly debated topic in the world at large. There's been some consensus lately, but this is still something that what the general public believes and what's actually true are two very different things, and we'll talk about why that is. All right, now lie detector test, more scientific term for this is the polygraph test. What a lie detector test does is it's supposed to be able to do what the name says, right? It's supposed to be able to tell when somebody is lying. So if somebody is a suspect in a crime and they're saying, no, I didn't do it, and you're like, well, I wish I had a way to know if this person is lying or not. One thing that people have historically turned to is the polygraph machine, a lie detector test. Now, how this works, the polygraph machine, it is not a magical truthometer, right? It works very scientifically. So it works by recording physiological arousal. So what happens is you get strapped up to this lie detector machine, as you see in the picture here. You get strapped up in a couple of different ways, and what the machine is doing is it's measuring your pulse, so it's how fast your pulse is, it's measuring your blood pressure, it's measuring your breathing, it's measuring how much you're sweating, right? It's capturing all of these physiological measures of arousal. Now, what people do when they are taking a lie detector test is the person administering the test, after getting the suspect all hooked up, right, what they do is they start out by asking some baseline control questions. So they ask for known truths. So they start out by saying things like, what's your name, where are you from, information that they have verifiably correct answers for. So they know your name, they know, where your address is, all that good stuff. So the idea here is that they're getting a baseline for the physiological arousal that you're experiencing that's being recorded by the machine. So whatever amount of arousal you're experiencing when you're telling the truth in these control questions that they can verify that you're telling the truth to, that's going to be their baseline. After they've established that, then they move on to ask crime-relevant questions. So, for example, where were you on the night of November 20th, right? Have you ever seen this person before? Did you commit this crime, right? They're asking the hardball questions here. The idea here is a simple one. The idea here is that if you are lying when you're responding to those crime-relevant questions, if you're lying when you're doing that, that should increase your anxiety, which should then increase your physiological arousal. And that's relatively well supported. The fact that when you lie, you tend to experience heightened arousal. So, maybe you breathe a little faster, you get a little sweatier because you're lying. In a situation like this in particular, when it's a high stakes lie in that case, this should be, compounded. You should be feeling very, very anxious when you're lying. Therefore, what the polygraph is recording should be indicating spikes in your arousal when you are lying for crime-relevant questions compared to your arousal at baseline when you're answering your name and whatnot. So the idea is simple, right? It should be that if you're lying, it should increase your arousal, and the machine can pick up on that. So it should be able to tell when you're lying. So that's how this works. It's not a magical truthometer, right? It's a pretty scientifically backed, or at least should be scientifically backed, way to tell when someone is lying. The question, of course, is does that actually work? So it's supposed to work that way, but does that actually work? Can you, when you're asking people these kinds of questions, does it catch people who are lying and who are actually guilty and vice versa? So there's been several studies that have looked at this. I'm just going to tell you the results of one of them that tests out how accurate lie detector tests are. Now, what they find in this particular study is that a whopping 98% of guilty suspects fail the test. That means people who actually did commit the crime, whatever their crime was in this situation, the vast majority of those guilty subjects fail the test. So that means that the polygraph machine picks up on their spikes in arousal. When they are lying, they're saying that they're innocent, but they're actually guilty. So it works pretty well to detect, quite well to detect guilty suspects. The flip side of that question, though, is if you are innocent of the crime, does the test clear you? So do you pass the test if you're innocent? And the answer is not so rosy. So the answer here is that 45% of innocent suspects also failed the test. That's almost half of the people who did not commit the crime, who were completely innocent, also failed the test. So the machine, according to the polygraph machine, it looks like they're lying, but they're actually not. Now, the reason this happens is because of what the polygraph is actually measuring. It's not a magical truthometer, right? It's measuring your arousal. The idea is that by getting those control questions first of your name, where you live, that kind of stuff, that baseline, if there's a difference when you're answering crime-relevant questions, that should mean that you're lying. However, think about, put yourself in the shoes of somebody who's innocent and taking a lie detector test. If you're innocent taking a lie detector test, you're being asked these questions about a crime, that's probably going to make you nervous, right? It's a nerve-wracking situation. You're probably going to feel more nervous when you're being asked about the crime that you didn't commit, that you need them to know that you didn't commit it. You're probably going to feel even more nervous than when they're asking you your name. So in that case, that heightened nerves, which is just nerves, not lying, that heightened nerves looks like lies, and that means that you fail the test. So whopping almost half of people who are innocent don't pass the test. That indicates that lie detector tests are not, they're not infallible, right? They actually have a pretty bad track record when it comes to clearing innocent suspects. Now, this is a big problem, right? But I also want you to go back to that first point here. 98% of guilty suspects fail the test. That means 2% of guilty suspects pass it. That's a very small minority, but still, some people who actually commit crimes pass that test. The way they do it is often because some studies have indicated that it's actually possible to fake responses in this kind of test. So one thing that I've heard as being a way that you could do this is by, when you're being asked the control questions, to pinch yourself, for example. So you get a little bit of a pain, it spikes some of your physiological arousal when you're answering your name and where you're from and whatnot, so that then when you're lying on the crime-relevant questions, it looks like your control questions, and it looks like you're not lying at all. So it's possible to fake responses. This also gets into some other interesting stuff. Have you ever heard of this idea of psychopathy, right? This kind of, I guess you could kind of think of it as a personality disorder where you're a serial killer, basically, right? But psychopaths have been shown to have smaller amygdala, so they have smaller emotion processing centers in their brains. And so when they lie, they don't experience those spikes in physiological arousal. So a lie detector test doesn't work for that kind of person at all, just because they're experiencing different physiological arousal just in their everyday life. So lying doesn't affect them the same way it does other people. So that could also contribute to that 2% of guilty suspects who pass the test. And this is certainly not the only, this is just a little tiny taste of lie detector tests, right, as well as inadmissible evidence. Like I said before, there's a huge amount of research on social psych in the law and cognitive psych in the law, right, all different areas of psych and how it applies in legal settings. And really important, right, for the same thing we watched that, or you had you guys watch that video on Ronald Cotton earlier in this lecture. This is important. This is changing people's lives, and it's important to know what shortcomings there are in legal settings like these. So if you're interested in this, for example, if you're a criminal justice major or you want to get involved as a victim advocate for your job post-college, I definitely recommend you spend some time, looking at more information about this kind of stuff, reading some more research on this stuff for what people know about how psychology is relevant in the law. All right, so that brings up to our second review activity here. So video lecture response number 2 here. Now that you know a little more about how social psych concepts are applicable in legal contexts, go ahead and write a paragraph or 2 answering the following questions. So what things should you keep in mind if you're ever the victim of a crime or witness a crime? And then what should you keep in mind if you ever serve on a jury? Because these are things that might happen to you, right? It might have already happened to you. So in that case, given what we know now from social psychology, what are things to keep in mind? So go ahead and put this on the same document that you wrote the first video lecture response to. So feel free to put that on the same document there. Just give me a paragraph or 2 applying what we've talked about in today's video lecture to these contexts. Once you're done with that, then go ahead and come back here and we'll wrap up the last couple slides of the lecture here. All right, so now that you're back, you've completed your video lecture responses. Let's go ahead and wrap up. All right, so now we've been talking about these different topics and how social psych is relevant in these different areas of the legal process with regard to eyewitness testimony, inadmissible evidence, and how well lie detectors work. All right, so to wrap up the things we talked about today, we started out this video lecture by talking about eyewitness testimony, how it's actually quite unreliable and very subject to cognitive biases, right? So we saw that case study what happened to Ronald Cotton, the very huge consequences of inaccurate eyewitness testimony. He lost 11 years of his life. Can you imagine his life was never the same after that? To spend 11 years in jail for a crime that you did not commit based on someone's eyewitness testimony who really thought that she was being accurate, right? That just shows the massive limitations that eyewitness testimony has. And yet, for most people, what's more convincing than someone pointing the finger and saying, yes, that's the person who did it? So most people find eyewitness testimony to be incredibly convincing, and yet it has these huge problems, right? We talked about how these often stem from memory problems. And if you went and stopped the average person on the street and asked them how memory works, they probably would not give you the correct answer, that it's not a camcorder, right? That it's subject to bias at every single stage, from encoding to storage to retrieval. Most people just don't know the limitations that memory has, and therefore how it could affect eyewitness testimony. We also talked right about how eyewitness confidence doesn't necessarily signal accuracy. Those two are actually unrelated. So the more confident you are as an eyewitness does not necessarily mean you're being more accurate, but most people think it does. So judges and juries who are making the decisions relevant to the cases find it incredibly convincing. So it's really important to know the limitations in legal proceedings like that. We also talked beyond eyewitness testimony. We talked about how inadmissible evidence still affects jurors. We saw that study where that evidence was ruled inadmissible, but we saw that instead of going back to the baseline where the people didn't hear the evidence at all, people actually used that inadmissible evidence even more in their decision making, even though they thought they hadn't used it at all. So it shows that you can't really strike something from your memory, right? Whenever you see, people in these courtroom dramas who are conjecturing, speculating about the suspect's motives, and then somebody else says, oh, objection, strike that from the record, that's just speculatory, whatever. Whenever people do that, right, they're doing it for a very good reason, because the jurors still heard that speculation, and it's still going to be in their minds when they're considering the rest of the evidence. So it's important to know that that stuff still gets considered when juries are making decisions. And then we wrapped up by talking about how lie detector tests can make even innocent people look guilty. We saw that they're actually not very good at all at detecting when somebody is not lying. And that's because they're not magic lying, they're not magic truth detectors. Instead, they function based on measuring anxiety, right, physiological symptoms. But people can feel anxiety even when they're not, even when they're telling the truth about not committing a crime. And people can, fake their responses to not appear anxious even when they really are. So there's big limitations to keep in mind for this kind of test. I do want you guys to know, by the way, I don't think I said this earlier, that in most legal settings, people do understand nowadays that lie detector tests are not accurate. So you typically won't see these used as evidence. Sometimes you still will, right? It's important to keep in mind the limitations. But for the most part, people in legal settings do know the limitations of this kind of test, even though they might not necessarily know about inadmissible evidence effect on jurors and about the limitations of eyewitness testimony. And then more broadly, going back to our, the second video lecture response here, is to keep these things in mind if you're ever in a situation in which they might apply. So if you ever witness a crime, or you're falsely suspected of a crime, or you serve on a jury, all things which might happen to you or might have already happened to you, keep in mind the things we talked about today, right? The limitations in eyewitness testimony, how that evidence can affect jurors, whether lie detectors are really legit or not. These are all important things to know in a situation like legal proceedings where huge decisions are being made about people's lives. It's important to know the psychological things that go into these different processes. All right, that brings us to the end of our video lecture. So be sure to submit your video lecture responses, the document that has your responses to the first and second questions, to the Blackboard Dropbox. That's due Thursday, April 26th by 11:59 p.m. So this is our last day of class for social psychology this semester. The last Thursday of class is here, 11:59 p.m. This is the same due date as the career paper, so just make sure you upload them each to the appropriate Dropbox. And then even though our class is over now, right, I hope that you will continue to see the relevance of social psychology in your daily life. We talked in this video lecture about one particular applied situation where social psych is very relevant, but it is certainly not the only one. So almost anything you could think of, any career you might have, any situation you might be in the future, there are social psychological concepts that could be impacting how other people or how you are thinking, feeling, and behaving. So keep in mind, lots of social psychology in the world all around us to continue to observe and read up about and learn more about throughout your life. All right, that was nice and corny. So if you are watching this before our last day of class, I will see you in our last day of class. We do a wrap-up activity to kind of summarize everything we've learned about so far this semester. If you're watching this after the last day of class on Thursday in the evening, for example, then I will see you at the final exam. Let me know if you have any questions. Otherwise, I will see you later.